Welcome to the UGC NLUD e-Pathshala project on competition law, and the paper we are going to discuss is dominant position and its abuse, which specifically talks about identification of abusive use of dominant position, and we are trying to see that how a dominant enterprise abuses its position in the relevant market. The learning outcome of this particular module is that the learners would be able to enumerate the conduct which would be termed as abusive under the Competition Act, and in fact they would be able to understand and examine that which are the points which needs to be considered. We will see some of the cases also in this, and they would be able to explain the concept of unfair and discriminatory conduct in purchase and sale of goods and services, which is one of the factors. Second, they would be able to explain the concept of predatory pricing and explain the concept of leveraging, which is one of the components of the abusive conduct which is enumerated in section 4 of the Act. Here we need to mention one thing, that the courts which are used from the CCI orders may not be final because they may be at the appellate stage, and the learners are requested to update themselves with the latest order which is available in the competition appellate tribunal, or maybe thereafter if it went to Supreme Court, then the decision of the Supreme Court. With this particular disclaimer, we begin with the module, and if you see the section 4 of the Act tells you about the definition of dominance, and then we see that how this particular dominance will be utilized or has been utilized on the basis of a complaint which has been received under section 19 of the Act by the Commission, or suo motu action taken by the Commission, or maybe a reference received by a statutory authority by the Commission. It can take an action, and while taking an action it has to find out that which are the abuses the dominant position or the dominant enterprise has entered into. Now, the dominant enterprise may go into two kinds of abuses, and these are categorized around the world. The categorization is into two kinds. One is called exploitative abuse and the other one is called exclusionary abuse. The exclusionary abuse is basically the exclusion of the competition from the market. So, we have seen the definition of the dominant enterprise. It says that it acts independent of the competitive forces, or it tries to affect its competitors, consumers or market in its favor. While doing so, if it is excluding the competitors from the market, or it is excluding the entry from the market, and here we need to differentiate again that there may be legitimate practices of businesses and there may be illegitimate practices or unfair practices. So, here we are not concerned with that thin line difference of legitimate practice, right? We are concerned with the practice which is illegitimate or unfair to the competition in doing this particular aspect, or abusing or excluding the competitors from the market. Here I will give you one example of upstream and downstream market which happens. For example, there is a case of a margin squeeze. Now, here what happens is, if we are talking about a vertical chain, and in vertical chain suppose the raw material supplier is the dominant enterprise, and the raw material which is used for producing the product in future or by the other players in the market, and there is a discrimination between this raw material producer in providing the raw material at a price higher to the other players than its own unit, then definitely the outcome product will be costlier for the other producers than the dominant enterprise, and this will definitely affect the competition in the market, and this is not right. This may be exclusionary. So, this is how we go ahead. We will see more elaborate examples when we see the provisions of the Act. When you talk about exploitative abuses, this is basically a direct harm to the consumers, and this can be by way of a excessive pricing. So, suppose there is a dominant player in the market, he knows that there is no market entry, there will be no players which will be coming in the market, and this fact he exploits and thereby raises the price of the products, then definitely this is an exploitative abuse. Here we need to understand that around the world exploitative abuses may not be of a big concern than exclusionary abuses, because exclusionary abuses have a long term impact in the sense that competitors are excluded from the market and the rivals get, or you can say the dominant enterprise get a chance to raise the prices or abuse its position in the market because of absence of competitors in the market. So, it is a more of a concern, exclusionary abuses. In Competition Act, there is no difference between the exclusionary and exploitative abuses. However, if you see the Raghavan committee report, it has made a recommendation, or you can say it discussed this particular aspect of exploitative and exclusionary abuses and difference of it, but this thing has not been included in that. Now, the concept of abuse is basically an objective concept. It is a concept which has to be seen from the facts and circumstances of the case, and one has to find out, to see that what has happened, what are the factors, how it has been abused, and all these factors needs to be considered, and which was laid down in the famous case of ECJ in Hoffman-La Roche, and the commission examined that it is an objective concept. In the cases which the commission has examined, the Competition Commission of India, we can see it is an objective concept in the sense that all factors are being examined, all aspects are being examined. There are several things which are considered while determining that what kind of abuse it is and how exclusionary it was. Section 4 of the Act provides for 5 categories of abuses, which may be exploitative or exclusionary depending on the circumstances, and which we may categorize, but the Act expressly does not make a distinction. The first category is the abuse which relates to condition of purchase or sale and price in purchase or sale of goods. So, it is basically bifurcated into 2 parts, clause 1, subclause 1 and subclause 2. So, we say this 4(2)(a)(1) and 4(2)(a)(2). So, 4(2)(a)(4)(2) talks about, it says a dominant enterprise or group would be held to abuse its dominant position if it directly or indirectly imposes unfair or discriminatory conditions in purchase of sale of goods or service, or price in purchase of sale including predatory pricing, and this is predatory pricing is expressly mentioned here, and it has also been defined in the explanation, we will see that, of goods or services. So, the first part talks about the unfair imposition of pricing or discriminatory imposition of pricing. So, it relates to price. Now, the second part talks about price, second part talks about the condition in purchase. Now, let us see the first one, that is unfair and discriminatory conditions. Now, unfair and discriminatory has not been defined under the Act. However, the unfair and discriminatory has to be interpreted, as I said, it is an objective concept. It has to be seen that how unfair it is in relation to the allegation, at the same time in relation to the conduct which has happened in this particular matter. However, if we see, one has to relate this particular term of unfair trade practice, and this has been defined in the Consumer Protection Act, which essentially enlists a host of practices which is being adopted for the purpose of promoting sale, use of supply of goods or provision of any services. And there are several interpretations of Supreme Court and various courts which can be utilized in finding out that what is unfair and discriminatory. So, this is how the Commission examines it. Let us see, there are 4 cases which I propose to take in this particular aspect. One is the famous case of DLF, which talked about unfair and discriminatory conditions of purchase and sale. This was a case in which the apartment buyer owners were subject to one-sided apartment buyers agreement, which had an unfair and discriminatory conditions, a lot of unfair and discriminatory conditions. Let us enumerate some few of them. For example, there was an unilateral change in the conditions without concurring with the apartment owners who have bought the flats. For example, increasing the number of floors or the height of the building, so that the common area gets distributed between the more number of people. So, this was an unfair and discriminatory condition. There was a condition which was in relation to the interest payment. For example, if the purchasers defaulted, there was an interest rate as high as 18%, and if the DLF defaulted, there was an interest rate only of 5%. There were different other kinds of discriminatory conditions also which were examined by the Commission, and it was found that these are all abusive conditions, and that is how it was held to be in violation of section 4(2)(a) of the Act, and 630 crores was the fine which was imposed on DLF, which has been subsequently upheld by the Competition Appellate Tribunal, and at present you must be knowing that it is under appeal before the Supreme Court of India on merits. So, let us see what happens in this particular case subsequently, but the point which I am trying to make out is that unfair and discriminatory conditions can be interpreted in an objective way. So, it has to be seen from the facts to facts, right. And in this case, I would like to also point out the minority decision also. It is very important from a discussion point of view. If we see, the member R. Prasad gave a minority opinion in this, relying upon the Kodak decision, and if you see that particular Kodak decision, it talks about the aftermarket. So, here the member R differentiated two markets. One market is the sale of apartment and buyers, and second was the post sale, that was a different market. So, it says that there was an abuse by DLF in the post sale market. That is, once a customer is logged in with that particular apartment or with that particular builder, then definitely he has to comply with all kinds of conditions and objectives in the next thing. So, this was a very important thing to be considered, but it is a minority opinion, so not much of a relevance, but from an academic point of view, from a discussion point of view, this is very interesting and one has to relate this. In this particular case, there is one more development which is of importance, is that when the matter went to appeal before Competition Appellate Tribunal, the Competition Appellate Tribunal remanded the matter back to the Commission to see that how to modify the agreements. It is interesting that in one of the relief which the Commission gave, or the order which the Commission gave, it said that the DLF was directed to amend the agreements in consonance with the competitive principles. So, the compact directed that what should be the ideal agreement, and in fact, the Commission modified those agreements and gave a sample modification agreement to that. However, at a later point of time, that was turned down by the compact, which is again subject to appeal before Supreme Court. So, let us see what happens in this. So, a lot of things happening on the unfair and discriminatory condition area. Let us take another example of Pragati Maidan case. This was a case which was brought in by the exhibitors, and we all know Pragati Maidan is an area wherein lot of exhibitions keeps on happening, and the allegation was that ITPO, which manages this, that is your International Indian Trade Promotion Organization, which organizes this or manages this particular Maidan, has been held to be unfair and discriminatory towards the other exhibitioners than its own exhibitioners as far as the booking dates are concerned. For example, there was only 15-day period, cancellation period, which was available to the other people, and 45-day period available to the its own people. And these conditions, among others, were considered to be abusive. And in this particular case, the Commission again imposed a penalty, and around 67 crores was imposed as a penalty in this particular case. Coal India case is a case, and it is a very famous case for two reasons. One, that it involved a very important sector, that is coal, and second, that in this case there was a penalty against a public sector undertaking, making a point or proving a point that there is no distinction between a private enterprise and a public enterprise as far as competition law in India is concerned. And in this case, Coal India was alleged to have abused its dominant position in providing the fuel supply agreement with the electricity manufacturers or electricity plants in Maharashtra and Gujarat. So, there were around 4 or 5 cases which were presented, and in this particular case it was from Maharashtra State Electricity Generation Company, Mahagenco, and there was a case from Gujarat State Electricity Generation Company, and it were against the subsidiaries of Coal India Limited, and Coal India Limited was one of the parties. And the allegation was that they were not having a fair fuel supply agreement irrespective of the mandate of the government, and in this case the allegation of unfair and discriminatory conditions were that they were having unfair and discriminatory conditions in relation to the sampling, because they were not providing adequate samples, they were not providing the coal which was paid for, they were giving something of low quality coal, there were a lot of boulders and stones coming up in that particular coal, and there was no remedy left because the Coal India was in a dominant position. The power purchasers did not have any other option to move to some other producer, though there was an option for import of coal, but that was not a substitute for the coal which was provided by the Coal India. So, this is also one important point in this particular case which needs to be considered in relation to the module 17. So, you can refer to that there. So, in this case there was a penalty which was imposed by the Commission, and Commission imposed, it was one of the heaviest penalties, I think 1,700 crores in this particular matter on Coal India Limited and its subsidiaries. So, this matter is also in appeal, but the point which came up here is one very important point, was in relation to advocacy also. So, if you see in these particular cases in DLF also as well as in this Coal India, the commission said or made an observation that Coal India was not producing its optimum. So, it would have gone for more production. So, why it was happening? Because of its dominance. So, what was the observation of the commission? That if there would have been more players, definitely there would have been more competition, and that is how it was taken into. In DLF matter, the commission said that there was no real estate regulator and there was a need for having a real estate regulator, and that is why we need to consider this particular aspect of recommending for a real estate regulator, and in this particular case, in fact, the order was sent to the secretary and as well as the Haryana Urban Development Authority for compliance, and it was marked to government also to look into this particular aspect, that whether we can have a real estate regulator or not. In Adani Gas case, and it is another case which talks about the gas supply agreement, and in this particular case also it was found that there was an abuse by the gas manufacturing companies, and that is your Adani Gas, which was supplying gas in the Faridabad area, and Faridabad industrial users were using that particular gas, and this gas supply agreement had an abusive clauses. So, it was kind of a similar thing which we saw in the Coal India case. So, these are the different cases in which has been held by the commission as far as your abuse relating to condition of purchase and sale of goods is concerned. Let us come down to the second subclause of this clause, and that talks about unfair and discriminatory pricing. Now, differentiating the competitive and anti-competitive practices as far as pricing is concerned becomes very important, in the sense that discriminatory pricing is an aspect of business, and business should be free to price its product as it likes. So, one should not say that yes, this is pricing is high or low. That is why we see that exploitative pricing is not considered as bad. So, what is considered bad is the unfair and discriminatory pricing if it affects competition in the market. So, analysis is always in relation to the unfair pricing or discriminatory pricing is in relation to costs. So, what has to be determined is the cost of the thing, and that is why it becomes too technical, and it requires a lot of analysis to find out that what pricing is an unfair and discriminatory pricing. One of the seminal cases which has been decided by the commission in this is MCX and NSE case, and here the commission looked into the unfair pricing kind of a thing, and it said that the concept of unfair pricing was basically zero pricing can also be said. Zero pricing is unfair pricing, zero pricing is a subset of unfair pricing, that is what the commission said, though it could not or it did not go into the detail of predatory pricing in this particular case, and this was a case in which National Stock Exchange, we all know, is a big stock exchange, and it is one of the biggest stock exchange in India, and definitely a dominant player, and it was held that it was having actions, or you can say work in all area, for example, your equity, debts and all kinds of stock exchange services. But currency derivatives, MCX was the stock exchange which was only into the currency derivatives, and NSE entered into the currency derivatives market. What happened in this particular case is that NSE in the initial years started with zero pricing. Zero pricing in the sense it would not charge the currency derivative players for its platform or all kinds of services. So, this was alleged as an abuse of dominant position, in fact predatory pricing by MCX before the commission. Commission noticed and find out that there is a concept we should understand, there is a concept of penetrative pricing. So, this penetrative pricing, or advertising in the initial days, giving free products to the market or the consumers for the initial period is recognized, and it may be right, but how long? So, in this particular case the commission noted that this penetrative pricing cannot be, or promotional pricing cannot be for a longer period, and that is how it said that the unfair price or zero pricing by an NSE in currency derivative market was annihilating or destructive pricing, and it was beyond the parameters of promotional or penetrative pricing. So, this is what is an important case which is dealing with that. Let us see the concept of predatory pricing itself, because it has been defined specifically under the law, and explanation B to section 4 defines predatory pricing, and it says the sale of goods or provision of services at a price which is below the cost as may be determined by regulations of production of goods or provision of services with a view to reduce competition or eliminate the competitors. So, here the intention is important, and here the cost factor is also important. So, these are the two aspects which needs to be considered when you determine the predatory pricing. Now, determining the cost factor, there is a regulation which has been framed by the Commission for the purpose to find out that what is the appropriate cost standard which needs to be considered, and that is the Competition Commission of India Determination of Cost of Production Regulations 2009. Now, this regulation, briefly I would say that it says unless justified, that is section 3 probably, unless justified, selling a product by a dominant enterprise below the cost of production to be taken as average variable cost generally would be predatory pricing. So, if the cost of production, that is your average variable cost, is X and you are selling at a price minus X, then definitely it is a predatory pricing, and it should be, it is not right, and it is liable to be charged under section 4 2A 2. Now, there is a concept of excessive pricing, but excessive pricing is an exploitative pricing, as I said earlier, and by and large this price setting has not to be considered by the competition regulator. In fact, price setting is a mechanism which has to be considered by the sectoral regulator generally. For example, we have got TRAI, Telecom Regulatory Authority of India, and we see that this pricing are being determined by TRAI in relation to telecom sector. We have seen the 2G spectrum and all these pricing aspects. Similarly, if we see the insurance market, the pricing and all those things, though it is an open market, but still certain guidelines are being given by IRDA. Similarly, we have got pricing thing in PNGRB market. If you see, the PNGRB Act provides for the PNGRB authority or PNGRB board, which deals with the pricing in different petroleum products. So, this is how the pricing is being specifically reserved for the sectoral regulators, but competition regulators does not chip in specifically for the pricing aspect. But where does the pricing comes up is if it becomes unfair, and unfairness, there is a predatory pricing which we have already seen. But whether excessive pricing will be unfair pricing is a grey area which has not been touched upon as of now by the Commission. And as we said, the exploitative pricing or excessive pricing by a competition regulator is not desirable also. So, in exceptional circumstances, yes, it may be taken. Let us take an example of South Africa, where the things are different. It is here the excessive pricing has been expressly defined under the law, and it says a price for a goods or service which bears no reasonable relation to the economic value of that good or service, and which is higher than the economic value referred to above. So, basically it is talking about the economic value of the concept. Now, what is the economic value is again a interesting question, because how do you find out that what is the economic value? It depends on the analysis and determination. So, in fact, they have taken, South African law has taken the definition from United Brands case, where they talked about this economic value, but determination of this economic value itself is a big challenge. When we talk about this unfair pricing recently the Commission is seized with two, three matters in relation to unfair pricing, and that was in relation to FRAN terms, that is fair, reasonable and non-discriminatory access to the standard essential patent. So, it was in relation to the intellectual property, and this was a case filed, one by Micromax, the another by Intex, and these are the two cases in which the Commission took up with about the, against the Micromax the case was filed, and these are the cases in which it was alleged that the Micromax was not granting the access on fair and reasonable terms, and price is one of the factors in this, because they were charging discriminatory pricing for different players in the market, though according to the FRAN terms it would have been given at equal terms or equal access to different players. So, this is an area, a new area which is emerging and which needs to be examined further, or which needs to a further examination or a detailed examination which is under consideration by the Commission. So these are the this can be food for thought to go ahead for further discussion and further understanding. So let us see what happens in these cases. Going ahead, we come down to another kind of abuse, which is called royalty rebates and margin squeeze. Now this royalty rebates and margin squeeze is a kind of a unfair and discriminatory practice, and in this unfair and discriminatory practice what happens is that you differentiate. I have given already one example before, that you differentiate between the two your own supplier and the other suppliers. So in a downstream market and upstream market this happens, and in Intel case it was seen that EC imposed a fine on Intel for abuse of dominant position in the market of computer processing units by offering rebates to the computer manufacturers conditional upon them purchasing all or great majority of CPUs from it. So this was a kind of a case in which the maximum number of, the motivation was you can always offer rebates, but rebates only to the condition that yes, if you purchase 80% of our product, we give you this much of rebate, or maybe if you produce this much, we give you this much rebate. But your rebate should not be linked with a fact that you purchase the complete set of products from us only, then only we will be giving you this rebate, or you are binding that particular or foreclosing that particular purchaser from the overall market. That creates a competitive problem, which was the case in Intel case. Similar to that kind of a case, we had Kapoor Glass case, in which the Competition Commission of India referred to the practices of EU, condemning the discount policy of a dominant enterprise, which has exclusionary and exploitative benefits. And if you see, they referred to Hoffmann-La Roche case also of EU, and it was held that discount policy of the of your Scotch Kaisha was both unfair and discriminatory, and was violative of section 42A1 and 42A2 of the Act. And this was, they were discriminating between their own downstream player, upstream player, as well as and the other upstream player like Kapoor Glass. So it was a case which related to a borosilicate glass, which is used for producing ampoules, and these ampoules are used for producing the syringe ampoules. And Kapoor Glass produces these ampoules, but the raw material, that is borosilicate, should come up from the Scotch Kaisha. So this Scotch was selling this particular, it was alleged to be sold that this particular glass at a cheaper price to its own subsidiary than Kapoor Glass. However, there were certain other allegations also in this particular case. We need to go through the complete facts of the case to understand complete situation, but this is how we are talking about royalty debates. In case of margin squeeze, as I said, it is about your upstream and downstream player and discriminating between the upstream and downstream player. So that is how margin squeeze come up. Second class of abuse, which is mentioned in your section 4 of the Act, is about putting limitations or restrictions. Now this putting limitations and restrictions is by way of the dominant enterprise, because it is only the dominant enterprise and it operates independent of the competitive forces. So it has full motivation to do that, and what it can do, it can limit or restrict the production of goods or provision of services, or in fact also restrict the market itself, or it can restrict the technical or specific development relating to the goods or services to the prejudice of consumers. So if there is a dominant player, let us take an example. If we all remember that those were the days when there were no car manufacturers. It was only Hindustan Motors, and we had only ambassador cars in the market, or initially it was scooters when it came, Bajaj scooters. So we did not had any option. You examine a situation now when you have n number of cars, you get model every week. So that is possible just because of competition. If there would have been a dominant player, and we can imagine a situation that there was a dominant player and there was no motivation to innovate. Now it is something which goes by normal situation, it's fine, but if deliberately some dominant player restricts innovation, or it does not launch new product, or it does not go for innovation, and you find this particular thing in their policy document or their communication with their in-house people, that yes, we are not going to launch this, or we are not going to innovate this particular product because there is no competition in the market. So this is anti-competitive. Then in Kapoor Glass case, for example, CCI found that the practice of Scotch Glass to ensure that the converters do not switch over to other suppliers in upstream market, including imports, limits the overall market of the tube glass and is violative of the provisions of section 4(2)(b)(1) of the Act, which prohibits a dominant enterprise from engaging in any practice which limits or restricts the market. So, basically in this particular case, they have examined this particular aspect. Then we have got the third part, which talks about denial of market access. This is the third abuse which can be happening for abuse of by a dominant player in the market, and subclause C to the clause 2 of section 4 talks about this, and it says it would be an abuse of dominant position if an enterprise or group indulges in practice or practices resulting in denial of market access in any manner. So, it can be any manner. In a recent case which the Commission has got in this particular aspect is in relation to JCB, and there was an allegation by Bullsmart which were producing backhoe loaders, and JCB was imposing, JCB has restricted this particular Bullsmart from producing backhoe loaders by launching litigation in relation to that particular product, saying that this is a design violation, and in fact they were not able to launch this particular product in this market. If you see prima facie order of the Commission, Commission observed that JCB, by abusing their dominant position in the relevant market, sought to stifle competition in the relevant market by denying market access and foreclosing entry of Bullsmart in contravention of the provisions of section 4 of the Act. This is the prima facie view of the Commission. Matter is under investigation. And you see, what has happened in this particular case is there is a concept of bad faith litigation which is emerging up. Now, this bad faith litigation or sham litigation, though, is in relation to intellectual property. What happens is the parties, or you may say the dominant enterprise, tries to obstruct the non-dominant enterprise to enter into market by merely saying that there is a intellectual property violation of this, and since the matter is in litigation, they get an injunction over that, and the entry into the market, or you may cheaper product into the market, keeps restricted. So, this is an aspect which is of very great concern, and that is where you talk about denial of market access. When you talk about denial of market access, the concept of essential facilities also emerges. Now, this concept of essential facilities is a concept which emerged in United Railroad case in United States. However, later on if you see, the concept has been elaborated more by the European Commission in its subsequent decisions, and it has taken a back seat in US, because now they are no more interested in that essential facilities doctrine as such. But this essential facility doctrine basically says that it is a kind of a facility which cannot be replicated by the competitor, and its access would be required for people or for persons to do it. This particular aspect was considered by Commission in one of the cases, that is Arcia Rail, in which the question was in relation to the container transport, and the case was made by the container transport, and it was said that railway was abusing its dominant position in this market because it was not granting access to the essential facility, that is your railway line or maybe the platform, for the private players or private container transport, and it was giving preference to the Concor. However, the Commission held otherwise in this case, but definitely this is a very important case to examine as far as essential facility doctrine is concerned. But this essential facility doctrine needs to be further elaborated upon or dealt upon. In fact, I would refer to the latest car spare parts case of the Commission, in which the Commission has, though not expressly mentioned this fact of essential facility doctrine, but if you see, the spare parts has been considered as an essential facility, though not expressly mentioning it, which is required for the independent manufacturers, because unless you have that spare parts, you cannot independently repair the cars of other manufacturers. So, this is the concept. More importantly, if you see the National Competition Policy of 2011, the draft National Competition Policy, that also specifically talks about access to essential facility, and that is one of the key objectives of that National Competition Policy. So, these are the very important aspects as far as denial of market access is concerned. Though dominant enterprise in its pure volition or pure business principle, it is free to deny market access to anybody, but that denial of market access should not be with an objective to with an unfair objective, in fact, to create an anti-competitive situation in the market or to distort the market. The third one talks about tying and bundling, and section 4.2d speaks about this. And by virtue of this particular provision, the dominance, when an enterprise or a group makes conclusion of contract subject to acceptance of other parties of supplementary obligations, which by their nature or according to the commercial usage have no connection with the subject or other contracts, would be considered an abuse. So basically what happens in this case is, it is kind of a leveraging only, but not specifically leveraging. So here what happens is, the tying in is required, and there is a famous case under MRTP if you see, wherein there was a restrictive trade practices, when one of the famous examples can be of a gas distributor. You go to a gas distributor, he would say that to get the gas connection you have to take the gas stove compulsorily. So this was a kind of a famous example which was as a restrictive trade practices it was treated. But later on this restrictive trade practices has been removed under the MRTP Act, because in our law now we have abuse of dominant position. So if a dominant player forces the other or the market players or consumers to purchase one product in supplemental obligation to other products when they have no correlation altogether, then definitely that is of a consideration. Let us take one more example in this. Like a dominant player produces maybe what you can say a hair oil, right? Now this hair oil, he is a dominant player in that. Now he is a dominant player in the hair oil market, and there are no other producers of hair oil. So if a consumer has to purchase the hair oil, he has to go to that particular producer. Now what happens is, this producer says that if you have to purchase this hair oil, you have to compulsorily take a comb. Now this comb has no relationship with the hair oil, because now somebody can provide a justification like this particular hair oil will be best used when you use this particular comb, but you have to provide a scientific justification for that. Now that is something which can be provided, or in relation to some other product, that if it enhances the efficiency of the complementary product, but that is a different case altogether. But in this case, if it is the situation, what is happening is, in the comb market there are several players. So consumer has a choice of the products as well as of the prices, but in case of the hair oil, it has no choice because there is only one producer. So it is trying to use this particular position into the another market, and that is where it leads to our leveraging kind of a thing. Now what happens is, there is a concept of full line forcing. So full line forcing is something wherein if you want to buy one product of a producer, it says that you have to buy the n range of products of that particular producer. For example, you want to purchase a camera from Kodak. Now this Kodak says that when you purchase the camera from Kodak, you have to purchase its lens, you have to purchase its all kind of thing, and from here you have to purchase the battery also from Kodak. Now this is not right, because you can purchase battery from somewhere else, you can purchase lens from somewhere else, you can purchase the flash from somewhere else. Now it is on you, you can purchase the cover from somewhere else. If they are tying in, unless it is functionally justified that yes, the Kodak lens will not work unless it is accompanied with something else, right? So this is a very important aspect which needs to be considered here. What is important in this particular case is that there must be functional relationship between the tied and bundled products to justify that tying and bundling. If it is not so, then it will be an abuse of dominant position. So this needs to be considered. Now let us come to the last clause of this particular section, which is 4.2e, and this talks about leveraging. This particular concept of leveraging comes up from US, and it says that the dominant enterprise is trying to leverage its position in one market to another market. Now it says when a dominant enterprise or group uses its dominant position in one relevant market to enter into or protect other relevant market, then it is an abuse. Now friends, here if you see, this is a clause which does not feature in your European law. If you see the section 4 of the Act, it is in fact we have taken the definition, or we have taken these abuses as categorized in article 102 of the European Union law, and in European Union law this clause does not feature. However, if you see in European Union law, this clause has been interpreted in the case of a famous case called Tetra Pak case. The point of leveraging was considered by the Commission in MCX NSE case, And this MCX NSE case, we have dealt with the facts earlier. The CCI found that NSE had used its position of strength in the non-CD segment to protect its position in the CD segment to be in contravention of section 4(2)(e) of the Act, and that is how the provision has been taken into consideration. Now, let me come down to these are the abuses. Now, as far as remedies are concerned, section 27 of the Act provides for remedies, and section 27 gives 3 basic remedies among others. That is, 1, it can order cease and desist. Second, it can impose a penalty up to the tune of 10% of the average turnover of the last preceding 3 years, and it can give any other order. That is your section 27. But in relation to abuse of dominant position offences, there is a specific section, section 28, which provides for an additional remedies, and these remedies are that there can be an order to transfer or vesting of property rights, liabilities and obligation. There can be the adjustment of contracts either by discharge or reduction of any liability or obligation or otherwise. There can be the creation, allotment, surrender or cancellation of shares and stocks and securities. This subclause D has been deleted in 2007. The formation, which in fact talked about, I believe, compensation, which has been shifted to the compact, that is section 53N. The formation or winding up of an enterprise or the amendment of the memorandum of association or articles of association or other instruments regulating the business of any enterprise. So, basically we are talking about change in the structure itself, because behavior cannot be regulated. So, here in remedies we should understand that there are 2 kinds of remedies. One is structural remedies and the other one is behavioral remedies. So, structural remedies talks about the change of the structure of the enterprise. So, if there is a dominant enterprise, we try to break it, make it 2, then it is no more dominant, because then they will be operating independently. Then the extent to which the circumstances in which provisions of the order affecting an enterprise may be altered by the enterprise and the registration thereof, and any other matter which may be necessary to give effect to division of the enterprise. So, this is what are the remedies provided under the section 28 of the Competition Act in relation to abuse of dominant position, and we have seen there are 5 kinds of abuses which can happen by a dominant enterprise, and for this we need to prove it. There is one grey area in this which needs to be considered, and this grey area is in relation to whether the dominant abuse of dominance is a per se offence or a rule of reason offence. So, this debate I believe you people have already undergone under the section 3 provision, that is when we saw anti-competitive agreements. But in this relation, if you see the provision of the section 4 of the Act, it says that there is a per se kind of a violation, because it does not say that it has to be proved appreciable adverse effect of competition. But generally if you see, one has to go for a rule of reason in this particular situations. So, that is how the sections are arranged, and section 4 abuse of dominance talks about. The next module we will be talking on abuse of dominant position in US and EU, and we will have a kind of a comparative thing in module 19. Thank you.